Good morning, good afternoon, everybody. Welcome to our webinar on where competition law, antitrust meets employment law, or labor law. Can I just ask my panelists to come on screen, please? I would like to introduce everybody. I'm going to start with David. David Adu-Tutu is a partner in E&S Ghana in the commercial dispute resolution practice. David specializes in, amongst other things, employment law, and we will hear about his expertise today. His experience includes advising clients on arbitration proceedings, breaches, and contracts and other disputes. Our second panelist is Sandya Booluck. Sandya is an executive in E&S's competition law department. She is based in Mauritius, lucky fish. Before Sandya joined us last year, she was a principal merger analyst at the COMESA Competition Commission, where she saw a lot of things, and particularly mergers across the continent. And she's here to share with us some of her experiences in that regard as well. Last but definitely not least is Fritz Malan. He's an executive in E&S's employment practice. He's based in South Africa. He specializes in integrated employment solutions. He has advised clients in relation to employment law issues, not just in South Africa, but very much across the African continent, and in a number of jurisdictions there. In addition to being an African employment lawyer, he is also a non-practicing member of the Texas Bar. And his experience in that area will come in handy in our discussion today, particularly since we are talking about what is happening in the US and what the implications would be potentially for South Africa. So I'm going to start, before I start, let me just say, I think you saw on the screen that we ask that you please put your questions in the Q&A box. So don't use the chat box. Nobody's going to monitor that, but we will be checking out the Q&A box. And as questions come up, we will try to address them, or we will address them in the Q&A session. Okay, thanks. Okay, so I'm going to start off with Sandya. So, Sandya, what does competition law have to do with employment law? Why are we even having this conversation today? Where do the two meet?
Thank you, Liz. And I apologize in advance because there'll be a few reference to economic concept in my response. I apologize to the lawyers on the call. So traditionally, employment law is about the relationship between the employer and the employee. So it focuses on the rights and protection of individual workers, such as fair wages, safe conditions, non-discrimination, and general protection against unfair dismissal. Competition law, on the other side, is concerned about the structure and the functioning of the market as a whole. So at its core, it is meant to protect the competitive process of all markets, and that includes the labor market. So what's important to understand is that labor is not just a social or political concern. It is also an input into the production process. It is an essential input, just like capital, technology, raw materials. And importantly, it's a universal input. It's fundamental to almost every sector. So what that means is that the efficient allocation of labor, which normally comes from a competitive hiring process or competitive wage setting and freedom of mobility. So all of that is essential to having a productive and dynamic economy, right? So then what happens is, if you have firms that decide to collude on restricting employee mobility or fixing wages, which are the traditional competition concerns, the result is a less dynamic labor market. And in turn, that has consequences for the product market, for goods and services that we consume. And so companies will become less innovative, there's less productivity, and ultimately the consumers can suffer. Either you have higher prices or you've got a lower quality and lower innovation in the goods and services that are being put on the market. And this is where competition enters the space. So competition is not necessarily concerned with the fairness of the employment relationship, but rather it is looking at the freedom of firms to compete for skilled labor and the freedom of employees to move and seek better opportunities. And in fact, that is the message that is coming from the recent guidelines and the developments in the US and in Europe, as we will discuss during the webinar, is that the restraints in the labor market can be as damaging as price fixing or market allocations in product markets. And maybe to give an illustration, and Lizel, I will borrow from one of your examples actually. So there's the infamous 2005 email between Steve Jobs and the then CEO of Adobe. And so for the attendees on the call who may have forgotten about that email. So what happened was Steve Jobs found out that Adobe was recruiting Apple employees. And then so he sent out this email to Adobe CEO to say, I have a standing policy with our recruiters that we do not recruit from Adobe. It seems you have a different policy. One of us must change our policy. Please let me know who. Now, besides being a masterclass in email writing, what that exchange actually shows is a textbook example of how informal, so-called gentleman agreements can actually suppress competition in the labor market and then can attract the scrutiny of competition authorities. So basically, this is where competition and the employment laws intersect. So maybe I can pause here, Lise, before I venture into Fritz and David's employment world.
Thank you, Sandya. No, that's very insightful, particularly the email. If I recall correctly, that email was discovered as part of an antitrust case that the competition authorities, I think the FTC or the DOJ, I can't remember, brought against Apple and Adobe for so-called no-poach agreements, which is an agreement not to compete. Because that competition then would drive up wages if there was a competition for labor in that respect. So thank you very much for that. Fritz, over to you. Now, how has the South African Labour Courts traditionally dealt with restraints and non-compete clauses?
Lizel, the position adopted generally by the South African Labour Courts has always been that restraint of trades and also in the shape of non-compete agreements are in principle enforceable, subject to the application of specific policy considerations. And restraint of trade and non-compete obligations can never be unreasonable or overbroad. That's the underlying principle. But in order to get out of the starting blocks, so to speak, to enforce any restraint of trade, it's necessary for an employer who wants to enforce to show a protectable interest in one of two forms. And the protectable interest can exist either in relation to portable client relationships that an employee has been exposed to during the course of their employment and that they've been in a position to forge with clients, or alternatively by way of the proprietary business information that an employer is entitled to protect. So South African courts will not enforce a restraint of trade which is simply intended to restrict competition, or which restricts for an unreasonable period or has an unreasonable scope, either geographically or in terms of the industries that it relates to. The question is always in this regard, what would constitute reasonable protection of the employer's protectable interest? In relation to the issue of client relationships, the question is really, what is a reasonable period of time that one can restrict a former employee in order for a new employee to be able to forge client relationships that replace the client relationships that have left, as it were? Or if one is dealing with the issue of information, what is a reasonable period of time to give for that information to grow stale, as it were, for competitive purposes? So there's never going to be a situation where the mere fact that a former employee has marketable skills, for instance, which could be used to compete with a former employer, is a sufficient basis to enforce a restraint of trade. But at present, what one has to note, because that's obviously different from the United States, which we're going to talk about later, is that in South Africa, there's been no statutory intervention at all in relation to restraints on non-compete agreements and the scope that they can occupy in the marketplace. And compared to most common law jurisdictions, South Africa actually has quite a liberal enforcement regime, in the sense that a party that acknowledges that he or she is subject to a restraint of trade then attracts the burden to be able to demonstrate to a court why he or she should not be held to the letter of that restraint of trade, which is the opposite of what you find in most common law jurisdictions. And unlike in many common law jurisdictions, there's also no specific requirement in South Africa for separate consideration to be paid for a restraint of trade or non-compete undertaking to become enforceable. So in that respect, also quite different from what you see in a lot of common law jurisdictions. But the bottom line is it's regulated by court-made law. It's not regulated by statute to any extent.
Sorry about that. And Fritz, without putting you on the spot, I mean, you can see the potential clash between what the competition authorities would want, to allow employees to freely move between employers, to enhance competitiveness, as Sandya has explained to us. Have you ever seen a case in South Africa where that direct clash between, not in respect of the employee's right of earning a living, but that there has been that clash between the competitive market, or the market being freely competitive, versus the restraint?
Well, I've most certainly seen that thrown out in court papers as an argument. It's not an argument that the Labour Court is thus far bitten on. There has been arguments that have been presented in papers to say that does this not restrict the market too much? Does this not negatively impact this particular industry? But thus far, that has not been a consideration that the courts have taken on board. But I would venture to guess that that won't necessarily remain the position. I think the underlying economic considerations in a knowledge economy particularly is changing all the time. And there's a possibility that at some stage the courts might have to take cognizance of those type of factors.
Yeah, it would be interesting to see if somebody takes the cause up not in the labor courts, but takes it to the competition authorities by virtue of a complaint saying, well, actually the restraint is just to limit competition, etc. I've not seen anything like that in the competition space yet, but the winds of change that are blowing. So
yes, and it's very typical that some industries rely far more heavily on restraint undertakings than others. And that we do see is that typically in the telecoms industry, for instance, it's extremely common for disputes to arise because of it. And the question then ultimately does become, does it impact the market negatively that there's sort of a blanket application in particular industries of restraint obligations? And that most certainly is something that would make for an interesting competition law argument.
Agreed, and particularly the industry practice part of it. I think an absolutely excellent point there. David, over to you. What is the lay of the land in Ghana? And tell us a little bit, obviously, about the how employment law and restraints, etc., and non-competes are, considered by the employment courts, or the labor courts, or whichever courts deal with it in Ghana. And having regard to the fact that you don't have an operating competition law system yet, can I ask you in the second part to tell us what you think the impact of these changes in the competition law landscape or policy landscape might be?
Thank you, Lizel. So I'll take the second one first, if you permit me. There is some competition law. I say some competition law because it's a very scanty legislation. It's really a 6-paragraph legislation that seeks to talk generally about competition in a very broad sense. Has to do with protecting the reputation of entities, has to do with stopping entities from misleading the public as to what they do and how they do it. It's just a very broad one. It's not very detailed. And this law has been on the books for over 25 years. Actually 25 years. So it's a very old law. You could see that it started when competition was not so as huge as it is now. So the framers didn't really seek to tackle today's issues with competition. There's only one throwaway clause which can remotely work in the labor markets, and that is a provision that says that seeks to restrict the sharing of secret information. And again, it doesn't say specifically about labor or employees, but the argument can be stretched to include employees moving from one company to another who have there's a risk of sharing maybe trade secrets, maybe confidential information and stuff like that. And because the act is broad enough, it can be argued in that sense. But apart from that, it is really a matter of case law. And just some historical background. Ghana is heavily influenced by the common law, British. We've actually adopted the common law as part of our laws. So unless there's a statutory provision that says otherwise, the courts always go by what the common law position is. So the position is no different, is not substantially different from what Fritz has said operates in South Africa. Indeed, when Fritz was speaking, it was as if he was talking about Ghanaian law as well, because at the very basic, the courts look at what is reasonable. There are three general conditions that the courts look at when they are discussing whether or not to enforce restraint of trade provisions. And the first one is whether there's any legitimate interest to be protected. So for instance, is there a trade secret? For instance, is there confidential information? For instance, is there any customer relationships that may move from one company to another with the departing employee? And if there are such provisions, then the court will intervene and say, okay, then there's a reason to look at this restraint of trade provision, because then the company is at a disadvantage. The second one is, what is the scope of the restraint? And the scope is always in terms of duration and also geographical limits, because sometimes the restraint of trade provision will say you can't enter into any agreement with anybody in this city or within this geographical limits or within this country. So the courts always look at how wide is the scope and how reasonable is it for the employee who is leaving to find alternative employment if the employee leaves the employment. The second issue around scope is duration. For how long is it reasonable? And usually the courts take it on a case-by-case basis. So for instance, in a fast developing sector where innovation is always changing, the information that the person has today may not be relevant in tomorrow's market. So in that case, the courts will say, you know what, the information you seek to protect is not as critical anymore. So let's not limit this person's employment. So it's generally these things, and the overarching idea is always public policy. Doesn't make sense in terms of public policy to enforce this, and that is how the courts normally approach restraint of trade provisions here in Ghana.
Okay, great, thanks. I'm just thinking, you mentioned secret information. The sharing of secret information as being part of one of the factors that the Competition Act legislation would take into consideration. And I think Sandya is going to talk about this a little bit later, in terms of what the kind of things are that the policymakers are interested in. But interestingly enough, one of them is also the sharing of competitively sensitive information, not necessarily in the context of employer A moving to, or employee A moving to a new employer and taking those secrets with him, but employer to employer, if they exchange wage information, that can lead to a price fixing arrangement on as regards wages, that would also be considered problematic and undermine the competitive framework and the competitive markets that Sandya spoke about earlier. So Sandya, the competition regulators in the United States has taken up the cause, in terms of looking at the competitiveness of labor markets. Will you tell us a little bit about what those developments were? I think Fritz are also going to talk about more the legal side, the court cases that were there. But if you can tell us about what you've seen on the policy front, what is happening?
Sure. So just for context, so in the United States, you've got two main overall competition bodies. You've got the US FTC and you've got the US DOJ. And what they've done is they've come out with policy guidelines. So starting back in 2016 and more recently updating the guidelines, I believe, earlier this year. So they've issued guidelines that clearly set out their position against what they call naked no-poach agreements and wage fixing agreements. So maybe just to take a step back. So wage fixing agreements, as the name says, it's agreements between businesses not to collude businesses on workers' salaries, but it is not just limited to wages. It is also in relation to any other terms of compensation, so your benefits, your bonuses, other terms of employment. And it does not necessarily need to result in all of the businesses agreeing to a single wage rate, but it can also be discussions about the range within which to set those wages. And the other term you might have been hearing is no-poach agreements or no hire agreements or no solicitation. There's a number of different alternative wordings for that. But basically, it's agreements between businesses or individuals between the competing businesses not to hire, solicit, or otherwise compete for current, former, or potential workers. And what's interesting in the guidelines that have come out from the US is that the concern is not restricted to agreements between competitors, but it also extends, it can also apply to agreements between franchisees. So if there are agreements between franchises in different locations, prohibiting their workers from moving or shifting to different locations, for example, because they are seeking, better conditions or better wages, that can also be looked at by the competition authorities in the US. And of particular interest in the new guidelines, the 2025 guidelines, is that it also applies to agreements with independent contractors. And that's really coming out of the technological markets where we've seen the big five being quite naughty in terms of some of the provisions that they have included with their suppliers. What we've seen from some of the other practices is also internal company practices. So not just agreements between competing businesses, but also in terms of practices within the company itself with its current employees. So where you've got restriction on employees from leaving the work to join a competing firm or a potentially competing employer, or where you've got restrictions from leaving their job to start a new business, or even requiring workers to pay a penalty upon leaving their job. So all of those mobility restraints have been included in the US guidelines as potential practices that the authorities might look at. And it's important to also distinguish, so there are what we call per se restrictions. So there, the understanding is that irrespective of the actual harm on employees or on the market, if the parties and the businesses have entered into an agreement to collude on wages or to collude on not poaching employees from each other, the FTC has this position that that there should be an outright ban. And I think Fritz will talk a little bit more about the cases and where it stands, because there's been legal challenges. But it's important to distinguish there are what we call per se prohibitions, and then more practices that will go under the rule of reason. And this is more closely related to the cases that Fritz and David mentioned, in terms of you have to look at the proportionality and the necessity of some of the restraints, because there could be legitimate interests that are being protected.
Thanks, Sandya. Before I hand over to Fritz, I just want to check if there's anything in the Q&A. There is. The question here for you, Sandya, and I'm going to give you an opportunity to just quickly think about it, but I'm going to chat to Fritz first. Is non-compete clause in contract of employment lawful in the Mauritius jurisdiction? So we will look at that in a moment. But over to you, Fritz, to tell us about the developments that you've seen in the US when you put on that Texan bucket hat of yours, particularly in respect of non-compete clauses and restraints of trade. What have you seen happen in the US? What have been the developments? And then are there any implications for South Africa, for Ghana, for Mauritius, for the rest of Africa? I mean, I know you do a lot of work. How do those winds of change influence what's happening here on the continent?
Thank you. Yes, Lizel, with the United States, the position regarding the enforceability of non-competes and restraints has traditionally and historically been regulated by the states, not by the federal government. And in most states, there's some form of regulation that we'll go to, but in some states, there's also no regulation whatsoever, and the common law position, as David and I discussed, is simply applied. But the Federal Trade Commission has taken a view that non-compete agreements binding employees are in principle undesirable and represent an unfair trade practice. And in April 2024, then attempted to impose a very wide-ranging ban nationally on these type of agreements. But what then happened is that there was a case in Texas in federal court, and then another case in Florida in federal court, where these two judges, federal judges in different courts, both held for slightly different reasons that the FTC, in fact, lacks the power to impose a national ban, particularly with reference to whether Congress has specifically empowered the FTC to fulfill that function. The FTC subsequently appealed that decision, but what then happened is there was, of course, a change of administration in the US earlier this year, and the FTC subsequently asked for the appeals to be held in abeyance while it considers its position, and those appeals have not been concluded. So the position at state level, therefore, remains that there's quite a wide diversity in approaches between the different states, ranging from the very long-standing position in California, now followed by 3 other states, that renders non-compete agreements, whether entered into in California or outside of California, unenforceable in California. But that's still very much a minority position. The other extreme is also a minority position, which is to not regulate at all, except for the common law reasonability restrictions we've spoken of. And they're typically North and South Carolina, that's the position, but in a few other states as well. The most typical position, and this applies to 34 of the states, is that there's some degree of restriction, legislative restriction on imposing non-compete obligations on employees. And there you've got a wide variety. It's quite a smorgasbord of different types of approaches that gets followed. A typical approach which is followed in a number of states, including, for instance, Virginia, Maryland, and Colorado, is to just restrict the income level below which you can't impose a restraint. In other words, that all non-competes, that only employees earning above a certain level can be made subject to a restrictive covenant of that nature. And then there are some states, and here you'd be looking at Texas, New Mexico, a number of the southwestern states, which restrict or ban the imposition of non-compete agreements in relation to specific industries or professions. And the most typical one there is the medical world. But strangely enough, also in a number of states, for instance, the broadcast industry, where you are not allowed in, I think it's Illinois, for instance, to impose a restriction in terms of a non-compete on people in that industry. But what one does see happening over time is that the general trend at state level is most certainly in the direction of more limitation and restriction of non-compete agreements to improve the position of employees in the market. So what you're not seeing yet is a wide-ranging approach to ban. As I said, there's only 4 states that take that approach at present. And it's interesting how the different states clearly also maybe depending on what kind of industrial base they have. California, big knowledge economy. big innovation economy. California, for that reason, it seems, has always taken a view that this is simply not good as an economic principle and in terms of competition generally to have these kind of agreements around, and hence the aggressive approach. Whereas more sort of base level economies, the economies that are more reliant on natural resources and so forth, it seems that the opposite position tends to be taken. But in terms of what this means for South Africa, this movement that you see in the United States, I would say that in terms of the employment law implications, probably not that much, in the sense that South Africa doesn't often track what the United States does from a policy perspective in relation to employment. But I do think an area which is relevant is obviously the area of competition law, because it might be that through that avenue, which has traditionally been far more influential in Africa and in South Africa from the United States, the competition law area, where the Americans are obviously innovators and have been some of the originators of the basic antitrust type of principles and so forth. Through that channel, it may very well be that some of these principles of limiting these type of undertakings and agreements do find their way. But there's no clear sign of that at present, but the underlying economic considerations may be very similar over time and might drive in the direction of, if not the Californian approach, then maybe something more restrictive than what we have at present.
I find it interesting, actually, and you may correct me if, but that it's half counterintuitive that in a knowledge economy, the restraints are unenforceable, because it sounds to me like there's, and excuse my layman's use of your technical language, there's more of a protectable interest in a knowledge economy than not, or am I missing the boat?
No, I don't think that. I think that is a correct observation. It is somewhat counterintuitive, but I think where the difference lies is that it doesn't mean, of course, that confidential information and intellectual property won't be aggressively defended. I think that will be the case, but I think it's simply been a matter of consideration of the balance of economic benefit of either having these highly innovative and skilled employees able to change jobs very easily, weighed up against the downside of potential discouraging of industries that are very knowledge-based in a state where it's very easy for people to move around. But I think probably the balancing factor is the aggressive defense of intellectual property and of confidential information, because of course that you can restrict in a place like California for an unlimited extent. There's no restriction on that.
Because it does for me sound like the public interest is put above the individual's,
yes.
The individual employer's interest, to put it that way.
That's exactly right. Yes, I think that's exactly right. There was a view taken of what's best for the whole industry and for the whole state.
Yeah. Can you answer the question in the Q&A block about employment restraints in Mauritius, where the question is a non-compete clause in a contract of employment lawful in the Mauritius jurisdiction?
I cannot. That's not a question that I have an immediate answer to. I think I'll hand that over to Sandya.
But I think that question is more of an employment law question.
Yes.
Sure, and I was actually going to say the same. I don't want to pretend to be an employment expert, and I think certainly the principles that David and Fritz have alluded to earlier. So in Mauritius, the employment over restraints of trade on labor would normally be, or has for now, been looked at under employment laws. So I think the courts would tend to balance the interest, so the employer's interest in protecting confidential information and client relationship against the employee's right to work and right to move. So I think as a matter of general principle, you would need the restraints to be reasonable. And as I think David alluded, it has to be reasonable in terms of time, in terms of geography, and in scope. But what's interesting is that as of now, the Competition Authority of the Competition Commission of Mauritius has not yet looked into labor restraints. So for now, it is still very much under the sphere of employment laws. But we will see if that changes because COMESA has ventured into that area. So it will be interesting to see if Mauritius as a member state of COMESA also lends itself to peer pressure.
Well, while you have the mic, Sandya, maybe just tell us about what you have seen in COMESA.
Sure. So what was actually quite surprising when we started discussing this webinar and the topic, and I realized that COMESA has actually been quite at the front of the curve when it comes to looking at restraints in the labor market. And maybe before I speak about the specific case, so just for context, the COMESA Competition Commission and the COMESA Competition Regulations, so the objective stems directly from the COMESA Treaty, which has as its mandate or as its objective to promote regional integration in the common market and also to promote the free movement of labor as well as capital goods and services across the region. So the COMESA competition regulations are designed to give effect to the objectives of the treaty. And in so doing, they prohibit anti-competitive agreements, including those that have the object or the effect of partitioning the common market. So where you would have restrictions prohibiting, for example, labor mobility across or between the different member states, that could potentially be captured, even though it is not explicitly stated as in the US. So you don't have a separate set of guidelines specifically speaking about labor restraints, but the provisions dealing with anti-competitive agreements are sufficiently broad, which is also the case in South Africa, also the case in Mauritius. So there is nothing really that prevents the competition authorities from looking at it. And so interestingly, what COMESA did, so back in 2018, and to the best of my knowledge, that's the only time where there was a condition attached in relation to a no solicitation and non-compete restraint. So it was in relation to the Vivo Engine merger, and what the Commission, so it identified concerns in relation to non-solicitation of employees and non-compete clauses in the merger agreements that the parties submitted as part of the merger filing. So note to the clients on the call, you need to be careful about what is contained in the merger agreements as well, because the competition authorities do look at each and every document that is submitted. So what happened in that case is that the Commission considered that the duration of those labor restraints was not proportionate because the buyer was already present in the jurisdictions concerned. It already had sufficient expertise and know-how, and therefore the duration was not reasonable in terms of against wanting to protect the interest or the value of the target. So in that case, the parties undertook to limit the duration of the no solicitation restraint to 2 years in Kenya and to 3 years in, I think, a few other jurisdictions where the buyer was not as present and needed a bit more time to develop the business. And what's interesting also is that COMESA has published draft amendments to its regulation. So these are still being considered. It published them back in 2024, early 2024. We are waiting for to see the final amendments as they are being discussed through the internal COMESA organs. But what's interesting is that specifically in relation to merger assessment, the proposed amendments explicitly state that the Commission will consider the impact of non-compete and non-solicitation restraints in its assessment. So it does appear to now formalize this process that it will look at labor restraints, and labor restraints, according to a general principle, will need to be necessary, proportionate, and limited. And it's all ties in with the COMESA Treaty objective of labor mobility.
Yeah, excellent. Thanks, Sandya. That's very insightful. David, anything, any ideas of how the policy will affect Ghana or any other jurisdictions, and anything that you think that that employers should be noting of for going forward?
So thank you, Lizel. And to speak for Ghana, I don't think there'll be much of an impact on the changes. First, because it's not so widespread in the US, it seems to be affecting only a few isolated states. So it doesn't seem to be a policy shift for the whole of the United States. Secondly, also because Ghana does not have a lot of, we don't have a lot of effects on our legal market, especially from decisions or changes in the US market. We are more influenced by the changes in the common law position. And again, this area seems to be an area where there's already some law, even though it's not so much covered. And I know for a fact that there's a bill in Parliament currently which seeks to revamp the law. And the bill makes provisions for restraint of trade. And it seems that the position is going to be the same, that they will be restraint of trade provisions will be enforceable subject to conditions. We are waiting to see what Parliament will agree on to be what the conditions will be. And as the case is in Ghana, once Parliament passes a law, it trumps all judicial decisions. So the courts will then have to follow what Parliament is saying. So I don't expect the changes in the United States to have any effects yet. I think it will be easier for policy makers or influencers to start basically ramping up interest and putting some pressure on the authorities if it was a more widespread positional change in the United States. But as it stands now, I doubt that it will have a lot of impacts here in Ghana.
Okay, great for that. And Fritz, on your side, what do you think would be the implications for either South Africa or some of the other markets where you are active?
Yeah, as I say, I think it might be that, by example, at some stage, the same economic considerations may result in the temptation for legislatures to start intervening. I mean, we haven't seen anything that particularly drifts in that direction, but I think for individual employers, the important thing is going to remain to be quite sure that if one wants to impose these type of obligations, then one must aim at a very specific protectable interest and describe that well in terms of what you do and what you put on paper, and also to be very careful of standardized and blanket application. I think that whether in the current regime or in a more restrictive regime, the best position you can be in is to be quite considered in terms of who and why one applies these kind of restrictions, because I think the likelihood is fairly low that one is ever going to get to a position or very quickly to a position where there's suddenly some sort of a FTC style ban that comes about. But I do think that for all enforcement purposes, in any common law related type of jurisdiction, the important thing is going to be to make sure that one has a good way of implementing these things and thinking about what it is that you're trying to achieve and articulating that well. And because also practically just in the kind of, over the years, the restrictive kind of covenant fights that one has seen and in various jurisdictions, that's always the key issue ultimately, is how are things articulated? And then, of course, what is the reality of the situation? You can say on paper what you like. If there's no predictable interest, there's no predictable interest. And that's where very often employers tend to snooker themselves slightly by having a view that paper restraints, as it were, are enforceable, when that's never the case. It's always going to be about your predictable interest. And that's going to be the case with whichever regime you have in place. But I do think that, yes, watch the space. I think there might be some developments over time.
Okay. Great. This is perfect timing, Sandya, because I think you have spoken about what you think the changes are going to be, in COMESA and potentially spill over to the member states. We've got a couple of questions. Uzar, I'm sure I'm not pronouncing that correctly, and I apologize for that. Uzar says, thank you, Sandya. You mentioned that discussions around wage ranges could potentially be seen as anti-competitive. My question is, since many industries already have broadly known or publicly available wage ranges, how do we distinguish between unlawful wage fixing and the sharing or referencing of commonly accepted market benchmarks? This is every competition advisor's nightmare question. because it is, where is that line between what is, between black and white, and how broad is that gray line? So Sandya, over to you on that one.
Thanks, Liz. And I think to give some comfort, it's also an exercise that competition authorities have to rigorously perform, right? So there is also a duty on the authority to be able to demonstrate that. So what the competition authorities would normally look at is, does the wage range make sense? Does it make economic sense having regard to the sector or to the industry that is concerned? So where employers are setting wages according to industry standards that have come about as a result of competitive wage setting over the years, or as a result of following certain adherence to policies from a public interest perspective. So these are not as likely to be problematic as far as it can be demonstrated that it makes commercial sense to have those ranges. But where you have a group of employers that have their own wage range that is completely different from the rest of businesses in that sector, or completely different from other sectors, but that are still closely related, then it might pique the interest of competition authorities. So it's not a blanket yes or no, it's unlawful or it is lawful, but it is a matter of context and how you are able to demonstrate how did those wage ranges come about.
Perfect. Thank you. Thank you very much, Sandya. Like we always advise in these kind of situations is, don't blindly follow what's going on, and you must be in a position, if you are questioned, like Sandya said, to justify how you came to where you are, and that justification must not be because my competitor does exactly the same thing, or I've agreed with my competitor to do exactly the same thing. I see we've got a question from our friend Woody Stralong. She says, "Dear Fritz, it would be interesting to know how the difference between open source innovation systems like in India and closed source innovation systems like in the US would influence the reasonability of restraints. Do you have any comments?" That's our Woody. She goes for the difficult questions.
Yeah, I mean, the issue is again going to be what is the interest that is sought to be protected, and in terms of the different implications that those two type of situations may have commercially. The question is protection justified in circumstances where there's an open source scenario? Probably not. I can imagine that there is a difference in terms of how that would play out if there were to be a dispute, which plays out on the common law principles that David and I have discussed. So I think it would make a difference, because obviously also at the level of what information you're trying to protect, what are you trying to protect in a situation where the IP is not necessarily protectable, if I understand the concept correctly, because again, it ventures somewhat outside of my understanding of necessarily the commercial concepts, but I can imagine it would make a difference.
Thank you, Uri. Then we've got a question from Sisonke, and I hope that it's not the last question. So if you have any further questions, please post them in the Q&A. Sisonke says there's been talks about gig economy workers looking to get involved in collective bargaining. Would that potentially be treated as anti-competitive collusion in South Africa? So from a competition law, the Competition Act actually does not apply to collective bargaining. So it's exempted from the application of the Act, because actually, if you think about it, any trade union it's essentially a price fixing agreement between the members of that union, saying to somebody else, go and negotiate on my behalf what my minimum wage should be and what my increase should be. But so it's basically a price fixing agreement, but it's acknowledged by, from a policy level by the Competition Act that is not anti-competitive price fixing. It is actually in the public interest, because there is such a power imbalance between employees and employers. So, yeah, Fritz.
Yes, and from an employment law perspective, the rights of employees to organize and to bargain collectively is obviously constitutionally enshrined. So that's something that that they are entitled to do at all times. And yes, there's that exemption in the competition law, particularly to allow for that.
Excellent. Okay, I'm going to leave the floor open. Is there anybody typing any additional questions? Let's wait for a moment.
If I may just add to what Fritz
Please, David, go ahead.
actually, Fritz has taken the words out of my mouth, but it's the same here in Ghana. The collective bargaining is actually promoted by law. So if you look at our labor agreements, there's a lot of provisions that are made in favor of employees. But the Act goes on to say that if there's any provision in a collective bargaining agreement which is more beneficial, the Act defers to that. And then the Act also encourages employees to form unions. And then it makes it illegal for an employer in any manner to interfere with the formation of the union or any acts of the union. So collective bargaining agreements and unionization of employees is actually lifted a little higher above all other provisions. So it's not likely that a court in Ghana will see something like this as an infringement of policy or of any law. And then quite apart from that, you can also see from the attitude of the labor courts that they frown upon anything that sort of interferes with the employees' rights to come together to have a stronger voice than they would individually. So I don't imagine that such a move will be seen as infringing competition. But on an even broader level, the experience we have here in Ghana is that collective bargaining agreements are limited to each employer. So even though it may even be the same union, the conditions of employment differ from employer to employer. Is not the case, or I have not seen the case where a union has come together to say, for this union, all our members must have the same or the minimum amount throughout the employer, regardless of who the employer is. It usually also depends on how deep the employer's pockets are. So for instance, even in the same space, in Ghana, a lot of disputes arise in the mining and extractive industries around the collective bargaining and the trade unions. But even in those spaces, you can see from the different collective bargaining agreements that the wages or the conditions of service depend on the union's idea of how deep the pockets of the employer run. So you are not likely to find one union having maybe a minimum or having a standard fixed wage for its members throughout different employers. So in terms of likelihoodness of that even coming up, I think that's also very low considering the experience we have here.
Thanks, David. I'm going to see there's another question from Udi. It's to Sandya, but I'm going to put it to you while you have the microphone, David. To which extent are workers at risk who collectively voice their concerns against an employer's restrictive labor provisions on the basis that they constitute competing labor suppliers? I think this is that links on to what you've said. Your thoughts, please.
So the risks are very low. In Ghana, again, just to sound at the risk of sounding repetitive, the law actually protects employees a lot when it comes to acting in unions or unionized labor. So any action that is taken in the form of a union, if the worker suffers diminution of salary or other remuneration, if the worker suffers non-promotion, especially when the worker is entitled to it, and the worker can point back to the action of the union as the instigator, the law considers it unfair, and there's compensation for that. In the public sector space of employment, the courts go as far as reinstating an employee who has been terminated for engaging in any union practice. In the case of private employment, the courts do not will not go that far because, again, it's private and you can't compel a private employer to keep an employee. But the court will treat it as unfair termination, and there's a lot of compensation that comes with that. So in terms of that, there's a lot of protection for workers. I don't see a lot of risk.
Thank you. Sandya, do you have any additional comments on that?
No, and thank you, David, for answering that. But maybe just to add, so you also have a similar exemption under the COMESA competition regime in relation to collective bargaining. So in as far as it is related to enhancing or protecting employees' rights. So in that case, the competition law provisions on agreements would not apply to the collective bargaining of workers seeking to protect their rights.
And then Woody asks, and outside a collective bargaining context.
Happy to jump on that first, unless there are any burning intervention from Fritz and David. I think outside of the collective bargaining context, it can be a bit more nuanced because you would need also to assess whether we are now going into that boundary of setting wages in a way which is no longer competitive or which is no longer according to industry standards, whether it's from the workers collectively or whether it's from the employers on the other side. So I think you would need to just make a nuance in terms of what is the objective there, what is the intent there. Is it really just to protect the rights as we are discussing in a collective bargaining context? Or is it to seek something that the competitive market would not have offered?
Thanks, Sandya. Fritz, do you have anything to add? We've got 2 minutes left. So some closing thoughts or any ideas?
Well, I think that as I've mentioned previously, I think employers just need to be very cognizant of the directions that the law takes on this. I mean, even if one looks at the nuances that are built into the decisions around restrictive covenants and non-competes in the US and in South Africa through the case law, there's always good examples to build on in relation to specific industries. So I think it's the kind of area of law which is very policy driven, very much like competition law, and very much social policy driven. And for that reason, it's always going to be dynamic. It's never going to be completely static. It's actually been surprisingly static in South Africa for quite some time, but one anticipates that that won't be the case. So I think it's always important always to look at it from quite a considered perspective and just beware of those blanket provisions. You know, that's where the danger lies.
Thank you, Fritz. David, any closing remarks from you?
No, I think I'll just echo the words of Fritz. And it's really a matter of, in Ghana, it's a case-by-case issue. And in every situation, in every step that an employer takes, we always encourage the employer to act reasonably or to be seen to be acting reasonably. Because in the end, that's what the courts will look at. And if an employer is acting reasonably, and then it doesn't really matter how loud the employee shouts, whether alone or in a collective bargaining situation. But again, it depends on the court. So we always advise clients that, especially in Ghana, there are 2 forums that deal with these matters: the National Labour Commission and then the Labour Courts. And both forums are very employee friendly. So we always encourage clients to go overboard when you're trying to be reasonable. Make it so reasonable that even somebody who doesn't like you would come to the conclusion that it is reasonable. So you bend over backwards mostly. And that's for us, that's the safest way. But again, they are enforceable. So we don't discourage clients from considering at all.
Very practical advice there, David. Thank you very much. Sandya, closing remarks from you?
Thank you. I think I agree with Fritz and David, and I think the guidance really is watch the space. I think especially from the competition authorities side is, as you have with enforcement trends that gain momentum in the US and in Europe and in COMESA, as we've seen, there will be pressure or more attention being paid by competition authorities, even in our continent, especially in the current context of wanting to deepen continental integration. So there is likely to be more scrutiny on restraints on labor mobility.
Thank you, Sandya. That remains for me then to say thank you very much to the panel who have made themselves available despite very challenging schedules, some sniffles and illness and time differences. So thank you very, very much. I have certainly enjoyed sitting at your feet and listening to your wisdom. And thank you very much for your time and for a lovely webinar. Thank you. And thank you very much for everybody who has attended. We appreciate you taking the time. Goodbye, everyone.
Thank
Thank
you.
you.
Goodbye.
Bye.